CV21 is now in session.
Please be seated. We are here today in Win CACV 21-0655, Flagstaff versus ADOA. Each side will have 20 minutes to present their argument. Appellant, you may save as much time as you want for rebuttal, but you'll have to keep track of your own time. That's why we have a clock at the podium. We are recording the argument both in audio and video, so when you turn, please identify yourself so we can keep track of who's who. The argument should be up on YouTube in a day or two so you can see how well you did. We've read the briefs and conference the case. We know the facts of the law, so when you begin your argument, just start off with what you would like to talk with us about. Counsel, you may begin.
Good morning, Your Honors. Thank you. My name is Kara Carlson. I represent the Arizona Department of Administration. With me is Mike Catlett, co-counsel at defense table. I would like to reserve about 5 minutes for rebuttal. So in 2016, the city of Flagstaff voted to increase its minimum wage. Predictably, the cost of goods and services went up, and for the last 5 years, those costs have been paid by all state taxpayers, whether they had any connection to Flagstaff or not. In 2021, the Arizona legislature passed a budget that was signed into law on June 30th, 2021, by the governor, requiring Flagstaff to reimburse the budget units for the extra costs incurred as a direct result of the increased minimum wage. The assessment, importantly, does not limit the municipality's right to increase its minimum wage. It ensures that the 7 million Arizonans who had no say in the matter aren't subject to the choices of the 70,000 Arizonans who did.
Counsel, I think we understand the background. What we're dealing with here today is whether the court should or shouldn't have granted the injunction. Can you speak to that?
Yes, the court should not have issued the preliminary injunction. The July 31st date in ARS 35-121-01 should have been interpreted as directory.
Well, I mean, counsel, do we have to get to that issue? I understand that the trial court went there, but there seems to be a very meaty substantive issue that should be resolved after full briefing and analysis in the trial court. And so what I'm concerned about is whether the trial court should have granted the injunction or not. We all understand that there are 4 factors. Is there a factor that the trial court found that in your view it shouldn't have found?
Yes, Your Honor. I believe that the trial court erred in the beginning of the order. It correctly listed the 4 factors, but then later in the order, it stated that under Arizona Integrity Alliance versus Fontes, it could have just found on the legal sufficiency and not met any of the other standards. It did go through a cursory analysis of the other factors in the preliminary injunction requirement, I should note first that no other case has cited that Fontes case as a reason to say that the preliminary injunction standard has somehow changed. The preliminary injunction standard remains the 4-factor test.
So then, council, should all we do is vacate and remand for the trial court to review all 4 issues? Is that really the relief that we'd be looking at best, I should say?
I'm sorry?
At best, for your perspective, that it's just, look, you need to go through all 4 factors here. Go back and do that.
I think that while that is a possible alternative, I don't think that that is the best alternative, because the way the court has interpreted these statutes is legal error at its core. We're still going to have the issue with the plaintiffs are likely to prevail on the merits according to the trial court, and I think that there are some key legal issues that were wrong in that determination.
And isn't that why all that we're deciding today is whether the injunction should or should not have been granted? What the outcome on those legal issues ought to be after full analysis really shouldn't be addressed either by the trial court at the preliminary injunction stage or by us now on appeal from the granting of the injunction. Isn't the resolution of those issues downstream from us today? Or shouldn't they at least be?
Well, if the trial court, if this is remanded as you shouldn't have granted a preliminary injunction because you didn't really address the other key factors, or to the extent you addressed them, it was a really cursory analysis that didn't really get to the meat of the matter. The trial court may still feel bound to its erroneous interpretation of the legality, the underlying legality, and
well, but we can take care of that, I suppose, by vacating the trial court's analysis and telling it that that's a question on the merits. That whatever it ultimately decides, one way or the other, should be decided after a full trial and a full briefing, and not now. Would the state be happy with that outcome?
well, I think that in this case, time is really of the essence. I know every litigant says that, but a number of issues have occurred since this case first came before the trial court.
Give me the time of the essence. This is about $1 million to a state budget that is incredibly large. This is not even a rounding error, as they would say. How is time of the essence on this?
Because the lower court's order
Has no precedential value.
I understand, but the legislature, and while I don't represent the legislature did not pass an assessment this year or for this last fiscal year, presumably because this case was up in the
Okay,
air.
I don't think we can presume that.
Okay.
I think that's a step too far, and for me, as far as what we decide and why we decide the legislature does or doesn't act.
Well, what we can take judicial notice of is the fact that the city of Tucson, which is a much larger city with much more state
Is it in the record?
It is in the record. The city of Tucson filed an amicus brief in support of city of Flagstaff in the trial court below.
But not here.
Not in this case, but it is.
Well, I guess, we are a court of appeals. We're reviewing whether the trial court correctly or not granted an injunction. There is no doubt that what we rule may have an effect out there, but we aren't responsible for solving everyone's problems. All that we're responsible for is deciding the issue on appeal. And as I understand it, the issue on appeal is should it have granted the injunction or not. So what's the answer to that and why?
The answer to that is the trial court should not have issued the injunction. The answer to why you should resolve the other issues in this case is because matters of judicial comity and trying to preserve judicial resources and provide an appropriate framework for the parties to progress in future years to act appropriately and according to the law. Those are all very important factors that are appropriate to consider.
So let me go to the statutory interpretation issue that you're raising. It starts with a decision from the trial court that with regard to the July 31st deadline, correct?
Yes.
And what is that? Just so that I'm clear on it.
That the July 31st date in 35-120-101 should be interpreted directory because the two as directory, not mandatory. When you're analyzing whether a statute should be interpreted directory or mandatory, you're really looking at what the outcome is and what the trial court didn't deal with below. I mean, the trial court didn't address.
But then it went the next step, which is, and you didn't meet the July 31st deadline, correct?
Correct. The assessment was not.
So if we vacate that and have the trial court go back and do an analysis of the statute and look at the directory versus mandatory, isn't that all we need to do? And let the trial court really work through the legal issues and to the extent there's any facts that play into it, resolve that below before we decide how that statute should apply here.
That is definitely an option for.
And then we vacate the injunction. We say, hey, trial court, go take a look at whether or not this is truly directory or mandatory and go from there. I don't know why we would go beyond that.
Because our position is this really is not a fact-intensive case. The issues that are present in this case are very. I mean, we agree that the assessment wasn't issued on July 31st. The question is, what is the legal ramification of that?
Do you feel like, I think to Judge Goss's point, do you feel like it was fully briefed below, that issue was ready for the court to rule on when it did in its preliminary injunction ruling?
Yes.
You feel like it was fully briefed?
Yeah.
So there will be no purpose in having a trial on this. From my reading of the record, the trial court declined to merge the preliminary injunction issue with the merits. So the trial court thinks it's separate. And my understanding of preliminary injunction law and the procedure is that granting a preliminary injunction is just what it is. It's preliminary to further proceedings. And I've been on your side of the bench, and I fully understand that you may want us to resolve the legal issues so you can get on with what you need to get on with. But the preliminary injunction stage is prefatory to further proceedings. So why shouldn't we just decide that issue? And if you have such a strong argument as you obviously believe you do, can't you just argue that where you need to argue that and win or lose, then you can proceed from there?
Right, yes, we can do that. But again, I think that matters of judicial economy would lend itself to resolving these issues here, especially when the initial preliminary injunction was really based in law. It didn't raise these directory issues. It didn't raise the costs. It was limited strictly to the Voter Protection Act issue. So,
But Counsel, the Supreme Court came out with the case Arizona Free Enterprise Club versus Hobbs, which I think may affect how the effective date of the statutes operate. Can you address that? And isn't that something that the trial court should consider if we remand this?
I don't think that Arizona Free Enterprise versus Hobbs has that, is really relevant to this case. And I can discuss that more, but I would like to save time.
Well, if I could just, isn't, under Arizona Free Enterprise, I think it's accurate that this is an appropriation. And if it's an appropriation, it takes effect immediately. There's no 90 days. And that means that, and becomes all sorts of factual issues, that the government had plenty of time, the state had plenty of time to issue the notice to Flagstaff by July 31st. So if nothing else, think about that for your rebuttal if you don't have an answer right now. But I think that's what we're looking at. If Hobbs says this is an appropriation, that means it takes effect immediately. Why why the state didn't meet its July 31st deadline, even directory, could be an issue below.
I'm going to reserve that time.
Sure.
Thank you.
Good morning. May it please the court, Andy Gaona with Coppersmith Brockelman on behalf of the city of Flagstaff. To address the question that has thus far animated the conversation this morning, the trial court correctly issued the injunction, the preliminary injunction rather, and this court should affirm that injunction.
Well, so what irreparable harm has happened to Flagstaff? What we're dealing with is $1.1 million. As I read the record, the city has a surplus or a budget of $23 million. The money is already set aside. You win or you lose. You either get the money back or you pay the money. My understanding of irreparable harm is if it's just money, it's not irreparable by definition.
So two responses to that, Your Honor. First, the trial court did find that there was at least a likelihood of irreparable harm given the testimony that it credited via a declaration from the city manager that even setting aside that money, despite that the reserves that the city had, this is essentially an emergency fund to handle contingencies like wildfires and recessions, which is obviously something that is going to be entering the discussion now, both at the state and municipal level. But that just the act of setting this aside pushed the city towards those the contingency plans that are in place for spending those monies and triggering all sorts of things within the city budget that would cause cuts in services. Putting aside the fact that there was evidence, again, uncontroverted.
Well, counsel, isn't that a decision the city makes then? They have the money. And again, they could decide to cut services or they could decide to go into the reserve. I mean, I don't see how that's irreparable. And why is this an exception to the rule that for money damages we don't do injunctions?
So for two reasons, Your Honor. The first is that we've cited the court to a case from Illinois, the city of Kankakee case, I think I'm pronouncing that correctly, where the court said that particularly when you're looking at a municipal unit such as the city of Flagstaff that has a limited budget, that money necessarily translates into services. So when you go through this analysis, you are not just evaluating money in the abstract, you're evaluating the effect that the absence of that money would have on the city's ability to provide services to its residents.
Do you have an Arizona case, and what is your best case in Arizona that would follow that precedent?
Your Honor, I'm not aware of an Arizona case that is exactly on point there. And that's the reason we've cited the Illinois case to the court. The other thing I would say, Your Honor, is that there was a lot of talk in the briefing about what does the Fontes case mean. I'll just call it the Fontes case, the Arizona Public Integrity Alliance case. What does that mean? And does it really apply here when we're talking about a case that was not initiated in the first instance as a mandamus action? Now, the first response to that is, well, we do have a special action cause of action pleaded in the complaint here. So let's put that issue aside. But secondarily, if you look at the discussion in the Fontes case, and really I'm looking at paragraph 26 through 31, while the case procedurally was set up as a mandamus action, the court was not discussing granting special action relief in the form there of a writ of prohibition or a writ of mandamus. What the court was talking about was granting injunctive relief, and that's ultimately what the Supreme Court did. And what the Supreme Court said there is that once the city showed, once the challengers showed that the defendants acted unlawfully, they, quote, need not satisfy the standard for injunctive relief. But the Supreme Court didn't stop there, Your Honor. The Supreme Court went on to say that to actually examine the factors and saying in the alternative, we find that even if we applied the factors, the familiar factors for a preliminary injunction, they were met here. And they're met in the case of the city and ADOA for the same reason. Paragraph 27 of Fontes, quote, because the recorder's action does not comply with Arizona law, public policy and the public interest are served by enjoining this unlawful action.
Because I think that's the difference. In that case, what happened there was unlawful. You're litigating right now whether the assessment is unlawful or not. So it's bootstrapping to say, we say this is unlawful, and because we say it's unlawful, you have to enjoin it. What you're talking about is only effective if there is a prior determination that something is unlawful. If something has been declared unlawful, then yes, you would grant an injunction because you're asking for an unlawful act. But we don't know that yet. That's why the trial court needs to figure that out after a full briefing, and that's not what we have here. And to follow up on an earlier point, the state is asking for the $1.1 million. You can account for that in the current budget or not. But if you lose, you're going to have to pay that money, and services are going to suffer to the 1.1 million mark. So how does that, why does that matter?
So, Your Honor, taking your questions in reverse order there.
Sure.
It matters that the city does not have to pay that money now, because if it were to pay it now, the service cuts would happen immediately before we have final resolution of the issues, versus keeping the status quo, which of course is what a preliminary injunction is intended to do under these circumstances, and preventing those service cuts from ever happening in the first instance, or at the very least delaying them until final resolution of the case. So a cut to services now is a serious blow to the residents of the city of Flagstaff. And again, under that precedent, under the city of Kankakee case, to the extent that the city was required to show irreparable harm, it has shown that there is at least a possibility of irreparable harm even though what we are talking about here is money, because in this unique context, money translates directly into the services that the city is able to offer to its residents.
Counsel, can the city create its own irreparable harm? Because it seems to me that's what you're asking us to find. The city could cut services, but the city also could say, look, we are not going to cut services. That's not the right thing to do. We're going to dip into our reserve. That's what reserves are for. Is that possibility, which is entirely in the control of the party that's arguing it's irreparable, I'm not quite certain how I make those two track.
Your Honor, I don't think it's, of course, cities have budgets, and the city councils who are elected by the people have control over their budgets, and decisions always have to be made. There are finite resources no matter what. The problem in this case here is that causing the expenditure of that $1.1 million now, and causing the services that will be cut, or cutting into the reserve fund and potentially triggering recessionary spending contingencies, has an immediate effect when the city's belief and position in this litigation is that what would cause those things to happen is an illegal and unconstitutional assessment, that it was invalid on its own terms and is also violative of the Voter Protection Act.
And let's go to that then. What you have at best is a finding that it's likely you could prove it's unlawful. You don't have a finding that it is in fact unlawful. So how do I get, as Judge Howe was asking, to the Fontes resolution? Because you don't have the Fontes finding that you would need to support it.
Your Honor, I think that even pre-Fontes, courts in Arizona have always evaluated the 4 preliminary injunction factors on a sliding scale. And here, where I believe we have an overwhelming likelihood of success on the merits, and of course, that question is a pure question of law, at least with respect to the timing of the assessment and with respect to the Voter Protection Act. Those are pure questions of law that the parties briefed fully below, and they've now fully briefed to this court. And this court can make that determination. So using the sliding scale under Schoen and then the Brain versus Clean Elections Commission's case, I think the court can get there because there is at least a possibility of irreparable harm covered by a strong public policy against the enforcement of unconstitutional statutes or illegal statutes.
But that hasn't been determined yet. That hasn't yet been determined whether it's unconstitutional or not.
Your Honor, I agree with you that there has not been a final judgment finding that the assessment statute is either unconstitutional or that the assessment itself was illegal. What we have is the court's preliminary injunction order where it's passing on what were pure questions of law that were before the court.
So let me ask you this, and this comes back to the question I was asking them. With regard to what we need to resolve, I don't think your client disagrees this is an appropriation statute. And that's why the July 31st deadline was in fact valid and triggered. Or does your client dispute that this was in fact an appropriation?
This particular bill was not, this particular line item is not by its own terms an appropriation, and it was not part of the general appropriations bill.
I understand it wasn't in the appropriation bill, but when we go to the Supreme Court case law, more recent case law, it would suggest it wasn't in fact an appropriation, not subject to referendum. In other words, that piece couldn't be referred.
So, Your Honor, I know quite a bit about Arizona Free Enterprise versus Hobbs. I argued that case in the Supreme Court. And what I would say is I tried to make this exact argument that you did, Judge Goss, to the court, which is that if you construe the non-general appropriations bill, which of course goes into effect immediately under Article 4, if you construe that to include other statutes, then that means that while it may not be subject to referendum, it doesn't go into effect for 90 days. I do not believe that Arizona Free Enterprise versus Hobbs controls in this case at all, because while something that is an appropriation, and I don't believe this section of this bill is an appropriation, so I'm not conceding that point.
Okay, and I'm glad to understand that.
Yeah, assuming that this section of SB 1827, I believe it was, assuming that provision were an appropriation, then what is true is that it may not be subject to referendum because it arguably could be for the support and maintenance of state institutions, but it would not go into effect immediately because it falls outside of the general appropriations law. So free enterprise versus Hobbs, over my strong objection, still maintains that dichotomy in the statute. It's a peculiarity of the statute. Mr. Catlett knows it well too. He was involved in the briefing of that case. So I agree with what Ms. Carlson said in that I do not believe that a remand to, for example, to address how Arizona free enterprise versus Hobbs affects the analysis of at least the timing question, the statutory interpretation question. I don't believe that's necessary. And if the court would like this court would like further briefing on that, I'm sure that the state would agree with me that we'd be happy to submit a round of supplemental briefs on that issue to this court. Because
Well then, counsel, doesn't your argument make the statute a nullity? Because they couldn't timely issue it by July 31st if it didn't take effect until the end of September. How do you answer that argument then?
Your Honor, I believe the state called our argument on this hogwash in the reply brief, which is a vivid way to describe the argument of a party opponent, but what it lacks is...
I'm not doing that. I just want you to explain how you get there.
But what it ignores is Article 4 and all the tools that are available to the legislature. So, for example, nothing prevented the legislature, if the assessment were so important to the state of Arizona, we know it's not because it's a rounding error, but assuming it was, nothing prevented the legislature...
Rounding errors can be important to people.
That's true, Your Honor, but what I would say is, nothing, and if it were that important, nothing would stop the legislature from trying to garner the votes to get an emergency clause to put into the legislation imposing the assessment, in which case it would go into effect immediately and not be subject to referendum under Section 1.3 of Article 4. The second option that the legislature has on this front is to not engage in the budget brinkmanship that is not required by the Constitution, but apparently is preferred by our legislature of late, and having its sessions run as late as they do. If this assessment were passed as part of a legislative session that adjourned sine die in April, there would be no problem with the July 31st statute. And nothing prevents the governor or the legislature, through the constitutional tools available to them, from calling a special session that begin and end for the sole purpose of doing this and would start the 90-day period for the effective date immediately. Those are at least three ways in which the statute could function constitutionally. The other thing I would say, Judge Goss, to your point, is that the legislature itself chose this July 31st date, knowing well its processes, knowing well how it usually engages in running right up into the constitutional deadline in order to pass a budget, and it chose that date anyways. The legislature could have fixed that date after this ruling came out from the trial court if it thought that there was a problem and it wanted to impose the assessment whenever it wanted to. It chose not to do that, but nothing stops the legislature from doing that either. So there are at least four ways in which this statute could function constitutionally if the legislature wanted to do so. They chose not to do any of those with respect to the assessment that we are here talking about today. So the statute's not a nullity. Article 4 says that this argument is not hogwash, as the state would have the court believe. There is a legitimate way the state could exercise its power here, but it hasn't done so.
You want us to resolve all that here now?
Your Honor, I think I agree with the state on this point also, which is that there are, again, at least two pure legal questions and two legal avenues through which the court could resolve the preliminary injunction, at least the first factor, the likelihood of success on the merits. Whether or not the statute is directory or mandatory is a pure legal issue that has been briefed by the parties extensively, both below and here. And the Voter Protection Act, which I think is another reason that this court could affirm the preliminary injunction with respect to the first factor, is a pure question of law, again, briefed extensively by the parties both below and here.
So the trial court erred then in denying the motion to consolidate everything.
That was obviously our intent, Your Honor. The city's intent was to have this consolidated, and frankly, and Ms. Carlson, of course, can address this, if the case were to go back on a remand, I don't know that we would do anything more than file summary judgment motions on the record that already exists. It seems to me that there's not a whole lot left to do in the trial court. This is a pretty rare case where you have both parties urging you to reach these very important legal issues of significant importance both to the city and to the state, as you heard Ms. Carlson articulate. In fact, I don't think I've ever seen the state so vigorously urge against the application of the constitutional avoidance doctrine than I have in the briefing in this case.
In that regard, I suggest you talk about the VPN and why you think it's unconstitutional, because we haven't touched on it.
Sure. Your Honor, the question with respect to the VPA is, does HB 2756, does that amend what was Proposition 202? Now, Proposition 202 gave localities like the city the right to set their own minimum wage, a local minimum wage, subject to only a single condition, that the minimum wage exceed that of the state. The people of Arizona could have attached any other condition to the exercise of that right, but they chose not to. So this is ultimately a case about protecting the will of the people, both under Prop 202 and the will of the people of the city of Flagstaff as expressed through their own initiative measure that adopted the higher minimum wage. And I think you can resolve this case, Your Honor, by looking to a case that the state likes to point to and that I know Judge Goss is very familiar with, which is what I'll call the AZAN case, Arizona Advocacy Network. And specifically, I would point the court, and what I think resolves the VPA issue almost entirely, is paragraph 52 of AZAN, which says, quote, because the commission's investigatory authority comes from the act, the legislature may not limit that authority unless it complies with the VPA. In this case, all you have to do is substitute the phrase, the city's authority to set a higher minimum wage for the commission's investigatory authority. And the analysis that this court followed in AZAN should be precisely the same. The question that the court has to answer is, does this amend Prop 202? Which means, does it modify, alter, or add to the statute? And it absolutely does. It has placed a condition on the exercise of that right. And if I could, in the 50 seconds I have left, I'd like to give the court another example of this and why this is so pernicious and why the court should put a stop to it. In 2020, Arizona voters overwhelmingly approved Proposition 207, which authorized the limited use and sale of recreational marijuana. One provision of that statute, I can cite you to, is ARS 362857, which gave localities like the city the right to use its zoning laws under certain circumstances to limit the location and the operation of marijuana establishments. Now assume you have a lot of cities have done that. They've said no marijuana establishments. Assume we all of a sudden got a pro-marijuana legislature that said, cities, we know you have that right, but if you exercise your zoning power in order to exercise that right, we are going to strip you of all of your state shared revenue. That would absolutely run afoul of the Voter Protection Act. And this statute is no different. Your Honor, I see my time has expired.
Thank you, counsel.
Thank you.
A few quick points that I would like to address. The first being the Free Enterprise Club issue. First, as everyone's aware, that was not, that hadn't come down before this briefing, and so it is hard to go back and say this is what we would have done differently. Obviously, ADOA was doing the best it could to comply with what it understood to be the law at the time. However, if that rule or if that date is directory, then whether it should have, whether it is an appropriation and it should have been issued immediately or could have been issued immediately or should have been issued by July 31st, or it was fine that it, wasn't issued until September, the result is the same, that a directory reading would say that you don't strike the whole section just because the deadline wasn't.
And what I was just going to say is, the answer can be, I don't, or I don't know. But do you have a position, or your client have a position on whether or not this is in fact an appropriation based on that case?
I don't have.
And that's fine. I just want, is that something that's important to us, or is that a reason, and I'm just going to ask, that we send it back to the trial court and let you brief that issue? I don't know is okay.
Yeah, I don't know, and I don't think so, but because I have limited time, I would like to hit a few points.
I apologize.
So you asked if he had a state case for Mr. Guyona had a state case for the irreparable harm issue, and he wasn't able to provide you one, but we have one, a memorandum decision from this court where the city of Flagstaff was granted a preliminary injunction based on budgeting procedures and it being irreparable harm, and that injunction was struck because, in part, that was not found to be a sufficient basis for irreparable harm, and that's City of Flagstaff versus Desert Mountain Energy, 2022 WL 869624. Mr. Gaona also discussed the recessionary spending contingency plans that would have to go into effect. I do want to clarify something that didn't become, that I think is misleading in the record. The answering brief says, and I quote, that a loss of just a few $100,000 more from the general fund would trigger the city's recessionary budgeting mechanisms and plans. It's a 1.4 million in revenues, not in expenditures. It's the revenues. It's a loss of revenue that triggers the recessionary plan. Obviously, the City of Flagstaff's budget was north of $300 million. So expenditures, which is this is what this would be, have no impact on the recessionary plan at all. And that makes sense. As a city is growing, their coffers may be fine and they may be spending more money. It wouldn't make sense to have to go into a recessionary plan because everything is fine and you have all the money you want to make all the investments that you want. The recessionary plan isn't triggered until there's a decrease in revenues.
I don't want to take up too much of your valuable resources, but isn't that a fact issue that you've just raised, that we're really not here to decide whether or not there's something wrong or inaccurate in the record, something you should take to the trial court to figure out?
And perhaps I misstated that. I'm using that as an example that to the extent Mr. Gaona is arguing that there is irreparable harm because the recessionary plan would be triggered, that's
I get it now.
That's not accurate. My apologies. And I can see where the court is going here, and so we would just ask that, to the extent this is going to be remanded, if there's a vacate the preliminary injunction, because to the extent it is interpreted as law of the case, I believe we're going to be back here with some of the same arguments, and to preserve the court's valuable time. I don't think that is helpful to anyone, and my time has expired.
Thank you, Counsel. We appreciate your arguments today. We'll take this matter under advisement and will issue a decision in due course. The stand adjourned.
Thank you.